Okay, we now come to Group 12, Guidance on Use of Restraint and Seclusion. I call Amendment 44 in the name of the Minister, in a group on its own. Minister to move and speak to Amendment 44. Minister. It's been a long week, Minister.
Thank you for your patience, Presiding Officer. Amendment 44 requires the Scottish Ministers to consult on and bring forward statutory guidance on restraint and seclusion, and to keep this guidance under review. Managers of children's residential care home services, of secure accommodation services and of school care accommodation services provided within the same facility as a secure accommodation service will all be required to have regard to the guidance. Tomorrow, the Parliament will consider Stage 3 of Daniel Johnson's Restraint and Seclusion in Schools Scotland Bill. My amendment is separate from the provisions in that bill, but takes it into account, particularly in ensuring the guidance in schools and care services will cover the same issues. It will be important for the next Parliament to ensure that guidance for education and care settings and also for mental health settings is as closely aligned and consistent as possible, while taking account of the different considerations that might be relevant in different settings. My Amendment 44, therefore.
Martin Whitfield.
I'm very grateful to the Minister for taking an intervention just before she launches into her explanation, but I think it's right and it should be put on record to welcome the movement that the Government has had in this, particularly with regard to the bill and tomorrow, and also to pay thanks and contribution to all of the stakeholders, some of who I know are joining us in the Chamber, to move to the point we are at today. So I'm grateful for that.
Minister.
I'm very grateful for Martin Whitfield's intervention and absolutely agree with him in terms of those who have been driving this forward. This was obviously an issue that actually came up during the passing of the Children Care and Justice Act, and again heavily at Stage 2 of this bill. So I'm glad that we could come to a position that I hope is supported across the Chamber. My Amendment 44, therefore, is a start to further work on this important issue. Taken together, these two bills will benefit children and those working with them by creating a statutory basis for guidance on the use of restraint and seclusion. They will bring Scotland closer to achieving the ambition set out in the promise of being a nation that does not restrain its children unless in exceptional circumstances. And I move Amendment 44.
Thank you, Minister. No other members have sought to speak. Is there anything you wish to add by way of wind-up?
Nothing further to add.
Okay, the question is that Amendment 44 be agreed to. Are we all agreed? Parliament is agreed. Takes us to Group 13, Reports on Deaths of Care Experienced Persons. I call Amendment 153 in the name of Willie Rennie, in a group on its own. Willie Rennie to move and speak to Amendment 153.
I've brought forward this amendment in partnership with Duncan Dunlop, who gave incredibly forceful evidence, uninformed evidence to the committee through its proceedings. The Amendment 153 will bring new duties on Scottish ministers to lay before Parliament an annual report on the deaths of looked-after children and those up to the age of 26 in receipt of a continuing care or after-care service. As a result of this amendment, there will be a new focused and proportionate reporting duty, strengthening existing statutory notifications, processes and improving transparency and learning, so that we can reduce the numbers of preventable deaths in Scotland and better inform policy design and service delivery for our care experienced community. Now, Duncan Dunlop was wanting a much more expansive provision for those of all ages. But this is a start, and it's a start that he has welcomed. So I ask members to support Amendment 153 in my name.
Thank you. I now call the Minister.
I welcome Willie Rennie's Amendment 153 and his willingness to work with me after Stage 2 to find a suitable way to address this very important issue in the bill. There is clearly more to do to reduce the number of premature deaths among care experienced people of all ages, and I hope that our work to keep the promise will help make that happen. While there are statutory notification processes in place, improving transparency about the overall picture will help us know if what we are doing is making a difference, but also signal what more we might need to do to reduce the risk of premature death. That is what this amendment aims to do, in a sensitive way which respects the right to privacy of the family who have experienced the death of a care experienced child or young person. I encourage members to support Amendment 153.
Thank you. Willie Rennie to wind up. Press or withdraw 153.
Nothing else to say to press, please.
Thank you. The question is that Amendment 153 be agreed to. Are we all agreed? Thank you. That takes us to Group 14, support for adoption. I call Amendment 154 in the name of Fulton McGregor, grouped with Amendments 155, 156, 157, 158 and 159. Fulton McGregor to move Amendment 154 and speak to other amendments in the group.
Thank you, Presiding Officer. I'm pleased to open this group and speak firstly to Amendment 154. Peer support is one of the issues most consistently raised with me and others by adoptive parents and prospective adopters. Families tell us that being able to connect with someone who has lived the experience of the adoption journey provides reassurance, practical insight and a sense of community at key moments. Across Scotland, peer support is typically delivered by specialist third sector organisations, and given that provision and practice differ between local areas, the amendment places a duty on local authorities to take reasonable steps to promote awareness and uptake of peer support services where they exist. Promotion of awareness and update will be targeted to those who are provided with adoption services under the Adoption and Children Scotland Act 2007. This is a refined amendment and it continues to reflect my original aim at Stage 2 of ensuring that adoptive families can access meaningful structured peer support throughout their journey, and I want to place on record my thanks to the Minister and her team for working with me on that amendment. My other amendments in this group are, like my previous amendment in Group 9, intended to be probing amendments tonight. I am grateful for the opportunity to speak to these amendments, which focus on strengthening adoption support in Scotland and preventing adoption breakdown. These amendments were also raised at Stage 2, and I am keen to hear from the Minister about what commitments they can make in dealing with what these amendments intend to achieve. I do thank the Scottish Government and the Minister again for their constructive engagement, as well as the cross-party group in social work, whose work with practitioners, adopters and care experienced people have shaped these proposals, and I'd like to think that their voices are at the heart of these amendments. Taken together, the amendments aim to ensure that adoption support is recognised as a sustained and essential part of the system. Amendments 155 seeks to strengthen support by ensuring access to specialist post-adoption social work. Too often, families describe a cliff edge where support falls away once an adoption order is granted, despite increasingly complex needs. Amendment 156 highlights the importance of sustainable funding to prevent adoption breakdown, which is both traumatic and costly. Early support is more effective than crisis response. Amendment 157 would ensure that adopted children's care experience status is properly recognised, particularly in accessing mental health services, including CAMHS, in line with the promise. In CAMHS, we found through the work of the cross-party group that accessing CAMHS for adoptive children is a particular difficulty, and it's very much different from other care experienced children. I know that CAMHS and the Health Service Officers isn't the Minister's portfolio, but I do appreciate her acknowledgement of the work in this area as well. Amendment 158 would introduce a definition of adoptive breakdown and improve data collection, enabling better understanding, prevention and learning. Amendment 159 calls for a report on funding for therapeutic support, including the potential for a national fund to improve consistency and access across Scotland. These amendments are grounded in lived experience and professional expertise, with a clear message: adoption support must be sustained, specialist and preventative. Although I said most of these amendments would be probing amendments, Presiding Officer, I consider Amendment 154 to be a positive and practical step, and I encourage members to support that, and I move Amendment 154. Thanks.
Thank you. I now call Jeremy Balfour.
Thank you, Deputy President Officer. Can I thank Fulton McGregor for bringing these amendments forward? I would hope that maybe I'd be interested to see what the Scottish Government have to say in regard to, and in particularly in regard to Amendment 158, the collection of data around breakdown. As I've shared previously in the Chamber, a number of years ago, my wife and I sought to adopt, and sadly the adoption broke down for different reasons. And having spoken to many other individuals and parents who have been in a similar situation, there are multiple reasons for why that has happened. But sometimes, if you dig down deep enough, there are actually 2 or 3 core reasons why these adoptions don't work out, whether it's to do with placement, whether it's to do with lack of support. And I think it would be really helpful going forward, not only for Scottish Government, but for the agencies involved and for parents to learn the lessons and to see are there national trends and Are there things that happen in particular locations compared to other geographical locations? So I will be interested to see what the Minister has to say around 158, but I would maybe encourage Mr McGregor to push that, even if the government aren't in favour of it. Thank you.
Thank you, Mr Balfour. And I call the Minister.
I want to place on record my thanks to Fulton McGregor for his continued focus on this very important policy area and for bringing it to our attention with the amendments in this bill. I share his desire to strengthen adoption support. Peer support is highly valued by adoptive families, and Amendment 154 provides a proportionate way of strengthening expectations around promotion. I invite members to support it. Amendments 155 to 159 address matters relating to specialist post-adoption social work support, sustainable funding arrangements, recognition of adopted people's experiences, improving national consistency in understanding and responding to adoption breakdown, and access to therapeutic support. Now, as I stated at stage 2, while these matters are extremely important, placing new statutory duties at this point would risk creating expectations that are not yet fully scoped or deliverable across Scotland. However, I do want to clearly restate 2 commitments that I have made to Fulton McGregor. Firstly, I will make clear to an incoming government and minister that it should take forward work early in the next Parliament to develop a shared definition of adoption breakdown and consider improvements to the collection and the sharing of data. There will be a need and a clear benefit to work with local authorities, the Care Inspectorate, adoptive families and the third sector in taking this forward. Secondly, I will make clear to the incoming government and minister the need to review early in the next Parliament the adoption support sections of the 2011 Adoption and Looked After Children Guidance, and to consider issuing new statutory guidance on adoption support services under existing powers in the Adoption and Children Scotland Act 2007. While I would like to try and bind my successors to such a commitment, I of course can't, but I will make clear my strong view that this work should be prioritised, and I have absolutely no doubt that Mr McGregor and others will press a new minister on this. Finally, on Amendment 157, which seeks to ensure adopted people are recognised as care experienced when accessing services, I am aware this issue is particularly important to Mr McGregor, and I want to reassure him that the guidance and regulations to be published will include a broad and inclusive universal definition of care experience that explicitly encompasses adopted children and young people. It will also set out best practice for public authorities on how to engage with and support people with care experience, including facilitating access to public services. This will be co-produced and supported by a programme of engagement which will include the adoption community. I hope these commitments reassure Mr McGregor that the needs and the interests of people who have been adopted and adoptive families will be addressed. I encourage him not to press Amendments 155 to 159, and I encourage members to support Amendment 154.
Thank you. I call Fulton McGregor to wind up. Press to withdraw Amendment 154.
Thanks, Presiding Officer. I welcome the Minister's remarks there. I'm convinced with her stance that most of these amendments don't need to be within statutory requirements, and also, again, her strong commitment there for a future government. So I really appreciate that. And despite Jeremy Balfour's best attempts to tempt me to press Amendment 158, I won't do that today, but I will press Amendment 154. Thank you.
Thank you. The question is that Amendment 154 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 155 in the name of Fulton McGregor. Already debated with Amendment 154. Fulton McGregor to move or not move?
Not moved. And Presiding Officer, if there's any help, I'm not moving any of these amendments.
I'll have to go through them individually, Mr McGregor, but thank you for your assistance. The question, I call Amendment 156 in the name of Fulton McGregor. Already debated with Amendment 154. Fulton McGregor to move or not move?
Not moved.
Question, I call Amendment 157 in the name of Fulton McGregor. Already debated with Amendment 154. Fulton McGregor to move or not move?
Not moved.
I call Amendment 158 in the name of Fulton McGregor. Already debated with Amendment 154. Fulton McGregor to move or not move?
Not moved.
Question is that Amendment 158 be agreed to. Are we all agreed? No. Parliament's not agreed. There will be division and members should cast their votes now. And the vote's now closed. And the result of the vote on Amendment 158 in the name of Fulton McGregor is yes 41, no 66. There were no abstentions. The amendment is therefore not agreed. I call Amendment 159 in the name of Fulton McGregor, already debated with Amendment 154. Fulton McGregor to move or not move? Not moved. That is not moved. Takes us to Group 15, Children's Hearing, Composition, Functions and Location of Members. I call Amendment number 160 in the name of Martin Whitfield. Group with amendments as shown in the groupings. I point out that if Amendment 161 is agreed to, I cannot call Amendment 45 due to a preemption. Martin Whitfield to move Amendment 160 and speak to other amendments in the group.
I rose with a level of enthusiasm, Deputy Presiding Officer, and I welcome the opportunity to speak to these amendments, and I move Amendment 160 that it's in my name. The message from children and young people is very clear. They think it is enormously beneficial to them to be able to see the same faces, to hear the same voices, and probably most importantly, not to have to tell their stories at each and every hearing. And I am pleased that the Minister and other colleagues share my desire to see this enhanced level of continuity of panel members within children's hearing systems, and I note the National Convener is similarly supportive of this approach, and I welcome that. And I thank the Minister for her ongoing consideration of these matters and welcome the introduction of new provisions which will ensure that this issue, which will be a key part of the hearings process going forward, in ensuring that decisions on continuity are taken in the child's best interests. And that brings me to Amendments 160, 161, 162, 163 and 164, which, working with the Government, have created. And that makes, and my apologies to the Chamber, an interesting dynamic within this group, because there are certain cautious areas I would like to push the Government to further. And in doing so, I would like to explore the other amendments that sit in my name and in others' name within this section. So, to understand where this comes from, we have to look at the test that's being placed on the National Convener, which is to quote, have regard to the desirability, unquote. And indeed, earlier on in the Stage 3 amendments, we had discussions of the meanings of words and the challenges that we've had about interpretation of those, not just within this proposed legislation, with others. And there is a challenge to that about how effective it will be going forward. I absolutely understand that those in government, and I absolutely understand that the National Convener and those that sit around this, have the desire to meet that requirement that children and young people tell us, which is that they need to see the same faces and the same voices. The question is the extent that having regard to the desirability fulfills that. So my Amendment 167 addresses this and uses a test of reasonable practicability. So we have a choice, and I can reassure the Minister that the choice will be made by proffering the amendments that are here, because I'm cognizant of the concerns that was raised by the Minister at committee that the test of reasonable practicability can prove problematic. So shall we try logistical matters? So when there are challenges of logistical matters, there could be changes, but otherwise it should stay the same. And there is an alternative approach, which is Amendment 168, which would tie the chairing members to hearings within a certain local authority area. Can I welcome Ros McCall's amendments at Stage 2, which discussed the geographic nature and the challenge that was occurring, that people were being inquired to make decisions about young people whose circumstances, with as much honesty as can be given, they had no idea what the day-to-day life was like because they came from one environment and were making decisions within another. A way around this would be to tie the chairing members to specific local authorities. So it gets over the geographic problem, which I can understand was a problem. There's questions of legislative competence in that. But because it is attaching it to a specific building and hearing area, by the very nature of the young people that will go through that system, the vast majority will come in front of the same faces and the same voices that understand the environment with which they live. Amendment 165 again raises the concerns that I brought at stage 2 about the role of the Chair and requires the Scottish Ministers to produce regulations about the criteria which the National Convener must consider when deciding whether to appoint the person as Chair. I'm satisfied that this amendment will utilise regulations rather than putting these requirements on the face of the bill, and that is a more appropriate way of addressing the very valid concerns that were raised with the original amendment at stage 2. The criteria draw directly from the Hearings for Children report. Ensuring that chairing members fulfil these criteria is a vital component of introducing remunerated chairs. And if we are to have paid chairs, then they must possess the necessary competencies to fulfil the expanded role as envisaged by Hearings for Children. And Amendment 166 makes these amendments subject to the affirmative procedure. And I'll be very interested to hear the position of colleagues and indeed the Government on Jeremy Balfour's Amendment 45, which seeks to introduce similar regulations but perhaps in a less prescriptive way. So there is a range of amendments in my name in this section that allow options that are open to this chamber to decide. But I go back to where I started. It is the message from children and young people. It is clear. They benefit when they see the same faces, when they hear the same voices, and they don't have to keep telling their story each and every hearing. And I move the amendment in my name.
Thank you, Mr Whitfield. I call Jeremy Balfour to speak to Amendment 45 and other amendments in the
Thank you, President Officer. Can I thank Martin Whitfield for his amendments that he has brought forward and going through the different amendments. I do think we do have a choice tonight, and I think it is important that we at least take one of these amendments forward into the bill and ultimately into the Act. I will speak to my amendment in a moment. I am interested in amendment number 47 in Ros McCaw's name. I am just concerned that in some circumstances this simply may not be possible to find somebody always within that local authority area that lives there. And I'm just wondering, does she feel, and I'm sure she'll reflect this in her comments in a moment, that it's just too restrictive in regard to that? I absolutely get the intention behind it and I would agree with it, but I am just slightly concerned that it ties the hands too much. Amendment 45 in my name seeks to ensure, by way of regulations, that the role of the chair in children's hearing panels is clearly defined and set out in secondary legislation to ensure consistency across local authorities and to ensure the role achieves its aims and objectives. I think we can all agree that the role of the chair going forward in the children hearing, as is at the moment, is vitally important. I had the privilege for 20+ years of being a member of the tribunal that used to look at DLA and then at PIP. And I know from experience that the role of the chair in bringing the tribunal, and in this case the hearing together, is important, and he or she has far greater influence than other members, whether that is done deliberately or just done by the role in itself. And so when this bill was introduced, it brought in remuneration for the role of chair and panel members, roles that until this point were voluntary and unpaid. In meetings I held with SCRA, the Scottish Children's Report Administration, in advance of Stage 2 proceedings, they were very clear that remuneration of the chair role was not about enhancing or expanding the role, but improving the quality of the candidate selected to the position. By paying the chair, you will be able to recruit people, hopefully with sufficient skills, experience and qualifications necessary for this important and demanding position. Given the importance of his role and the influence they will have, now they have remuneration, Amendment 45 sets out the roles and responsibilities of the chair should be clearly worked out and documented through consultation and subsequent laying of regulations. This will ensure that current best practice can be shared from across the country, so we don't end up with postcode lottery, and the future chair appointments are fully aware of the position they're taking on, but they can work out what their role is. By not making sure that 32 local authorities have different systems, I believe this will give consistency. I'll give way to Mr
Martin Whitfield.
I'm grateful to Jeremy Balfour for giving way, and although not strictly speaking sitting within these group of amendments, does he share and does he feel it is worth putting on the record the concerns that have been expressed about the appellable nature of some of the decisions of a single chair, and accept this is not for it. But in the guidance that he's talking about, they are provisions that could start to be considered so that the redesign has a proper structure in it where decisions, however well meant but made erroneously, can be put right.
Jeremy Balfour.
Yeah, I absolutely agree with the member. I think I raised at stage 2 my concern of giving too much power and authority to the chair. The chairs often will get it right, but all of us are human and all of us make mistakes. I believe by consulting on the functions of a role, it will ensure that the existing chairs can feed into the process and not be excluded from moving on to the paid role, thus losing the valuable experience, talent and service. Any regulations laid will be subject to the affirmative procedure to allow a proper scrutiny by this Parliament before coming into force. I believe this is a way forward that will protect the chair and will make sure that tribunals and hearings across the country are done in a similar way, and I would ask members to consider it and vote for it. Thank you.
Thank you, Mr Balfour. I now call the Minister to speak to Amendment 46 and other amendments in the group.
Thank you, Presiding Officer. Amendment 46 in my name is a minor technical amendment which amends new Section 6B, and I encourage members to support it. Presiding Officer, I will not be moving Amendment 49 and the consequential Amendments 50 and 51. These amendments sought to provide scope for a single chairing member to discharge a referral in certain circumstances. But following additional engagement and feedback from the operational partners in SCRA on these provisions, the focus of decision-making by a single-member panel should be on whether grounds are established, rather than assessing evidence as to whether compulsory measures may or may not be required. Not taking forward these amendments does not affect the wider scheme and will ensure that it remains as effective as possible. It will be for a 3-member panel in all cases to consider whether a compulsory supervision order is required following establishment of the grounds by either a single-member panel or a full 3-member panel. On Amendment 45, as I advised Mr Balfour at stage 2 when he lodged a similar amendment, Section 177 of the Children's Hearing Scotland Act 2011 already gives Scottish ministers powers to make rules for children's hearings, including the functions of the chairing member. Procedural rules would be the more appropriate place for this level of detail rather than in a bill, and would still provide proportionate parliamentary oversight. I would hope Mr Balfour might agree and not press this amendment. Amendment 47 from Ros McCall and Amendment 168 from Martin Whitfield would potentially limit the ability of the national convener to hold hearings in every area of Scotland. We have previously legislated to create a national framework to support children's hearings and panel members. That approach operates around panel members' local living and working connections. Those arrangements work well, and every effort is made to ensure panel members are from the same area as the child at the centre of the hearing. If there are issues of availability, then neighbouring local authorities are the first port of call. It's also not uncommon for conflict of interest to emerge, creating a need for an urgent replacement from a neighbouring authority. To illustrate the issues that could be caused by Amendment 47, a panel member may live within a mile of a hearing centre but actually be ruled out as they reside in a neighbouring local authority. Conversely, a panel member may live in the very same local authority as the centre but live over 100 miles away, particularly in large rural areas. For these reasons, I don't consider that these amendments are desirable. They would limit the flexibility that's needed for panels to operate. Crucially, that flexibility is managed by the national convener, and this is a key part of his independent role. I hope Ros McCall and Martin Whitfield are persuaded not to press their respective amendments, and if they do, I would urge members to vote against Amendments 47 and 168. It's also for the national convener to recruit and train panel members, including chairing members. And I am satisfied that plans are in hand for a robust recruitment programme based on the qualities, the competencies and the skills which the national convener deems appropriate for the role of remunerated chair. The detail of this has already been shared with members of the Education Committee. Once finalised, that will form the basis of open recruitment to these roles. I hope Martin Whitfield will agree that his amendments 165 and 166 are unnecessary and will not press them. I am sympathetic to the intentions behind Ros McCall's Amendment 52 and Martin Whitfield's Amendment 167. We have shared ambitions here and are in broad agreement on this issue, recognising that children and young people have repeatedly told us that enhanced continuity would be a significant improvement to the children's hearing system. The key issue is whether the test being introduced is the right one, and I remain of the view that the practicalities of delivering continuity must be balanced with the best interests of the child. The amendment proposed by Ms McCall significantly complicates the test for national convener. Similar...
Martin Whitfield.
I'm very grateful to the Minister for taking an intervention, and I am right in saying that this is one of the things that will be monitored by which of the data capture further down the line. So if it becomes apparent that continuity is not matching the expectation of our young people, it will be noted.
Minister.
And I thank Mr Whitfield for making that point, and I think it reaffirms a lot of the things that we're discussing here today. You know, we are 4 years away from when the promise is to be delivered, and we're going to have to ensure that the policy changes that we're making and the non-legislative changes that we're making are having the intended effect. So, absolutely. Similarly, Martin Whitfield's Amendment 167 would create unworkable tension with his Amendments 160 to 164, which I do support. Those amendments set appropriate parameters while preserving the necessary limited flexibility. They ensure that the national convener applies the necessary tests in accordance with his role, but can take into consideration recommendations from the chairing member. I believe that they deliver an appropriate balance with decision-making power in the right place, and I am grateful to Mr Whitfield for bringing them forward. I would ask Ros McCall not to move for Amendment 52 and Martin Whitfield not to press his Amendment 167, and for us all to support Martin Whitfield's Amendments 160 to 164.
Thank you. And I call Ros McCall to speak to Amendment 47 and other amendments in the group.
Thank you, Deputy Presiding Officer. My Amendment 47 seeks to strengthen the role of local knowledge within children's hearing. At present, the requirement for a panel member to come from the child's residential locality is qualified by the words "so far as practicable," and that's the point that has been made by basically everybody so far. But I believe that local knowledge should not be optional. This is so important when we were looking at single panel members. And as I have mentioned at stage 2, the geography and the locale is of utmost importance. And actually, after I'd mentioned that at stage 2, I spoke to somebody else who'd been on a panel member who lived in Glasgow but had to go to Inverness. Now, whilst I understand that that was acceptable when it's a 3-panel member process, because that is one person living out with the locale, when you are looking at single panel members, you do not have that option. And it is essential that local knowledge should be a part of this process. Children's hearings were designed to reflect the communities they serve. A panel member from the child's area is far more likely to understand the local service availability, the environment that the child is growing up in, and the practical realities of any decisions being made. And this amendment ensures that decisions are better informed and more grounded in that locale. And that is why I think it is essential that we have to make sure that panel members are from the local area. My Amendment 52 focuses on continuity for children within the hearing system. For many children attending a hearing, as we have already heard, it can be an anxious and unsettling experience, and they have told us time and time again they want that continuity. Too often they're faced with different panel members at a hearing, requiring them to repeat their story time and again. This is not acceptable. This amendment seeks to promote continuity in the chairing of hearings so that wherever possible, the same individual is involved through a child's journey. And I know that that has been recognised. I note the points that the Minister has made on that, and I will reflect on them. But we do need to have a consistency that builds trust, reduces the need for children to relive difficult experiences, and allows for a deeper understanding of the circumstances over time. And thank you very much.
Thank you. I now call on Martin Whitfield to wind up. Press or withdraw Amendment 160.
I'm very grateful, Deputy Presiding Officer. And again, I think it's interesting, although this has only been a short debate on this section, it shows and highlights some of the complexities that as the developing children's hearing system moves into and the role of the national convener takes on, and then the chairs, it is worryingly, sadly, or possibly something that we will need to return to going forward. With that, I have nothing further to add, but I will press Amendment 160.
Thank you. The question is that Amendment 160 is agreed to. Are we all agreed? Yes. Parliament is agreed. Call Amendment 161 in the name of Martin Whitfield. Already debated with Amendment 160. I'd remind members again that if Amendment 161 is agreed to, I cannot call Amendment 45 as a result of a preemption. Martin Whitfield to move. Amendment 161. Question is that Amendment 161 be agreed to. Are we all agreed? Yes. That is agreed. Call Amendment 46 in the name of Jeremy Balfour. Already debated with Amendment 160. Apologies. I call Amendment 46 in the name of the Minister. Already debated with Amendment 160. Minister to move formally.
Moved.
The question is that Amendment 46 be agreed to. Are we all agreed? Are we all agreed? We are not agreed. There will be a division and members should cast their votes now. We're aware that I think the wrong amendment has been posted, so we'll rectify that and rerun the vote. Okay, the question is that agreed to Amendment 46 and members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 46 in the name of the Minister is yes 89, no 23. There were no abstentions. The amendment is therefore agreed. I call Amendment 162 in the name of Martin Whitfield. Already debated with Amendment 160. Martin Whitfield to move or not move. The question is that Amendment 162 be agreed to. Are we all agreed? Yes. No. The Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 162 in the name of Martin Whitfield is yes 87, no 24. There were no abstentions. The amendment is therefore agreed. I call Amendment 47 in the name of Ros McCall, already debated with Amendment 160. Ros McCall to move on up.
Moved.
Question is that Amendment 47 be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division and members should cast their votes now. The vote is now closed. And the result of the vote on Amendment 47 in the name of Ros McCall is yes 39, no 71. There were no abstentions. The amendment is therefore not agreed. Call Amendment 163 in the name of Martin Whitfield. Already debated with Amendment 160. Martin Whitfield to move on up with. The question is Amendment 163 be agreed to. Are we all agreed? Yes. We are agreed. Call Amendment 164 in the name of Martin Whitfield. Already debated with Amendment 160. Martin Whitfield to move on up with. The question is that Amendment 164 be agreed to. Are we all agreed? Yes. Parliament is agreed. That takes us to Group 16, Children's Hearings General. I call Amendment 48 in the name of the Minister. Group with amendments as shown in the groupings. Minister to move Amendment 48 and speak to other amendments in the group. Minister.
Presiding Officer, my amendments in this group are mainly technical in nature. Many have been developed after close engagement with the Scottish Children's Reporter Administration to identify where refinements might assist in ensuring the bill operates as intended. Excuse me. Amendment 56 adds the undeeming of relevant persons to the matters which can be considered by a pre-hearing panel where the reporter makes a direct application for proof. This will ensure that in rare cases where this is needed, it can be done at an early stage to appropriately safeguard a child's rights. Amendments 58, 59 and 61 make essential technical changes to clarify how a grounds hearing considers a child's understanding of the grounds, ensuring that they can proceed appropriately and proportionately. Amendments 48, 57, 62 and 71 are consequential to these. Amendments 60 and 63 to 70 ensure that a children's hearing can proceed in the absence of a relevant person who does not attend a hearing where that is appropriate. This will help minimise drift and delay and ensure children are not subject to unnecessary additional hearings or court proceedings. Amendments 175, 176 and 177 make minor changes to the bill to ensure the correct operation of the provisions which apply where the child is not in attendance and a grounds hearing is not satisfied as to the child's acceptance of a ground. Amendment 72 makes a minor drafting correction. Amendments 73 and 73A enable the Scottish Ministers to make rules under Section 177 of the Children's Hearing Scotland Act 2011, specifying the circumstances where the procedures set out in Sections 69B to 69E of the Act can appropriately be disapplied or applied in a modified form in relation to a referral by the principal reporter to a grounds hearing. This could, for example, take account of urgent referrals to a grounds hearing, such as where a child may be the subject of a child protection order or is in a place of safety, or where a relevant person in relation to the child is not likely to be in attendance at the grounds hearing. Such rules would be subject to Parliament's approval under the affirmative procedure. I want to thank Sheriff David Mackey for all of his work in support of the promise, not least in leading the work in the Hearings for Children report and in his subsequent engagement with me and government officials on key issues. I know getting the culture right in the hearing system matters hugely to Sheriff Mackey and indeed to us all, so that it operates with the best interests of children absolutely at its heart and throughout its approach. We are already making significant strides in embedding inquisitorial principles by changing the culture of all of the key actors in and around children's hearings. We intend to continue to work closely with Sheriff Mackey in this regard. I am grateful for his input his honesty and his detailed contributions, and I am aware he has some reservations about Amendment 76, and so I will not move it today. And I am incredibly sorry that, despite efforts and good intentions, we've not been able to find a way to give effect to one of the key aims for his work with the Hearings for Children report in this legislation. But if we are to put something into law, it needs to be right and have the support of all who believe in our hearing system. I share Sheriff Mackey's desire to see an inquisitorial approach at the heart of the system, so that how it operates reflects the best interests of children at its core and in its key processes. A signal statutory provision, while positive, is not necessary for us to fulfil our objectives and create meaningful change in the system. And even without a statutory provision, I can assure Sheriff Mackey and members that inquisitorialism will be a cornerstone of the modernised system. The substance of the changes made in this area will be done through regulations and guidance supporting the enhanced chair and through the vital work of the Redesign Board. Moving on, I understand the intent behind Ros McCall's Amendment 53. However, it is not appropriate for ministers to direct children's hearings, which are independent tribunals. It is for the National Convener of Children's Hearings Scotland to provide guidance on attendance. Moreover, the National Convener already provides comprehensive guidance for panel members, which will be updated as part of implementation of the bill. Similarly, Jeremy Balfour's Amendments 54 and 55 would inappropriately cut across the independence of the Principal Reporter. It is not for ministers to direct the Principal Reporter or his staff, particularly where it is essential for them to be able to take an individualised and child-centred approach in each case. However, I can assure Mr Balfour that the Principal Reporter will issue detailed practical guidance for his staff as part of implementation of the bill. I welcome Martin Whitfield's Amendments 178, 179 and 180, and I am happy to support them, and I hope members will too. In summary, I encourage members to support all of my largely technical amendments and Martin Whitfield's amendments. I ask Ros McCall not to press Amendment 53 and Jeremy Balfour not to press Amendments 54 and 55. Should they do so, I encourage members to vote against them. I move Amendment 48.
Thank you, Minister. I call Ros McCall to speak to Amendment 53 and other amendments in the group.
Thank you. Presiding Officer, my Amendment 53 introduces guidance around a child's attendance at hearings. Every child is different. While some may wish to attend and participate, others may find the experience overwhelming and distressing. And this amendment assures that decisions about attendance properly take into account the child's age, maturity and emotional well-being. It's about moving away from a one-size-fits-all approach and ensuring that participation is appropriate, supportive and in the best interests of the child. Importantly, it suggests meaningful participation where children are enabled to engage in the way that they feel is right for them. And I would urge members to support the amendment.
Thank you. I call Jeremy Balfour to speak to Amendment 54 and other amendments in the group. Mr Balfour.
Thank you, Presiding Officer. Amendment 54 and 55 deal with pre-hearing meetings with the Principal Reporter. Pre-hearing meetings between the Principal Reporter and the cared for child and their families do not currently take place in the children's hearing system. These pre-hearing meetings are a new procedure brought in this bill, was introduced as new section 69A, and I think they generally have caused some concern and confusion in the children's hearing sector. These concerns have been raised at stage 1 and at stage 2, but I'm not sure the Scottish Government have yet answered the concerns raised by those at the coreface of this work. Pre-hearing meetings, let me say, are a good idea. They could allow the Principal Reporter to meet the child and the family outside the hearing room in a more relaxed and informal setting. We would allow the Principal Reporter to explain the format of the hearings, who will be in the room, what support is available to the child, such as advocacy or legal aid, and help calm nerves and reassure families as to what is going to happen in a very stressful time. But with this good intention could also come unforeseen problems. For example, what if the child or family member starts asking questions but are better placed to be heard in the grounds of hearing? What if the Principal Reporter accidentally strays from the brief and starts discussing details of the case or how the case might proceed? There is no clear indication of how this meeting will be documented, how it will be recorded, and how it will be used in any future hearing. Now, while I see and others see the benefits, I think it is our duty as parliamentarians not to leave it to others to ensure that there are clear standards and rules regarding these meetings, to safeguard the children and families involved, and to ensure reporters are clear in their understanding of what can, and more importantly, what cannot be discussed outside the grounds hearing. As the bill is currently drafted, it states, and I quote, "Such other matters in relation to the children's hearing, or as the case may be, the hearing before the Sheriff, as the principal reporter considers appropriate." And the phrase that concerns me, Presiding Officer, is "considers appropriate." It is too vague. It's open to interpretation and thus confusion and possibly overspill. I therefore bring Amendment 54 back, as I believe it is a safeguard for both children and for their families and for the principal reporter to make sure that these pre-hearing meetings are dealt with in the right way. Amendment 55 in my name simply states that these new regulations regarding pre-hearing meetings are subject to the affirmative procedure to allow Parliament to scrutinise the vote and to make sure that when they come into force, they have had their say. I move both amendments in my name.
Thank you. And I call Martin Whitfield to speak to Amendment 178 and other amendments in the group.
I'm very grateful, Presiding Officer, and I would like to thank again the Minister and the Government for being able to work from stage 2 with regard to what appears before us today as Amendments 178 and 180. It addresses the concerns that are raised at stage 2 about the UNCRC not being sufficiently integrated into this bill, and they require consideration of a child's UNCRC Article 16 right, which is the right to privacy, to be considered alongside their ECHR Article 8 rights when determining whether to remove relevant person status. Amendment 180 provides clarity as to what the Sheriff Appeal Court must satisfy itself of in order to quash an appeal on a determination by a sheriff about a relevant person's status. And I'll leave it at that.
Thank you. And I call on the Minister to wind up.
I have nothing further to add, Presiding Officer.
Thank you. The question is that Amendment 48 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 49 in the name of the Minister, already debated with Amendment 160. Minister, to move or not move?
Not moved.
The amendment is not moved. I call Amendment 50 in the name of the Minister, already debated with Amendment 160. Minister, to move or not move?
Not moved.
Thank you. I call Amendment 51 in the name of the Minister, already debated with Amendment 160. Minister, to move or not move?
Not moved.
Thank you. I call Amendment 165 in the name of Martin Whitfield, already debated with Amendment 160. Martin Whitfield, to move or not move? Thank you. I call Amendment 166 in the name of Martin Whitfield, already debated with Amendment 160. Martin Whitfield, to move or not move?
Not move.
I call Amendment 52 in the name of Ros McCall, already debated with Amendment 160. Ros McCall, to move or not move?
Not moved.
Thank you. I call Amendment 167 in the name of Martin Whitfield, already debated with Amendment 160. Martin Whitfield, to move or not move? I call Amendment 168 in the name of Martin Whitfield, already debated with Amendment 160. Martin Whitfield, to move or not move?
Not move.
Thank you. I call Amendment 53 in the name of Ros McCall, already debated with Amendment 48. Ros McCall, to move or not move?
Moved.
Thank you. The question is that Amendment 53 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 53 in the name of Ros McCall is yes 41, no 72. There were no abstentions. The amendment is therefore not agreed. I call amendment 54 in the name of Jeremy Balfour, already debated with amendment 48. Jeremy Balfour, to move or not move?
Move.
Thank you. The question is that amendment 54 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 54 in the name of Jeremy Balfour is yes 31, no 82. There were no abstentions. The amendment is therefore not agreed. We move to Group 17, Children's Hearings, Advocacy. And I call amendment 169 in the name of Nicola Sturgeon, grouped with amendments as shown in the groupings. Nicola Sturgeon to move amendment 169 and speak to other amendments in the group.
Thank you, Presiding Officer. As Jeremy Balfour, I think it was Jeremy Balfour, said earlier, the basis on which independent advocacy services should be provided has been hotly contested during the passage of this bill. Should a young person have to opt in, or should there be a presumption of advocacy that a young person has to opt out of? I have always tended to the latter view, not because I think advocacy should be imposed on young people. The right to opt out, of course, ensures that that is not the case. But because I have a concern that putting the onus on a young person to opt in will inevitably mean that many fall through the cracks, either because they are not aware or don't have the confidence to ask for the advocacy that they are entitled to. However, rather than push a general opt-out approach through amendments to this bill, because I don't think there is consensus around that, these amendments were an attempt at a principled compromise. They seek to provide for an opt-out approach in cases where a hearing is considering an order or a variation of an order that would place a child in secure accommodation, or which would otherwise restrict the liberty of a child, or where the child is suspected of a criminal offence. To me, it seems important that in these circumstances there should be a presumption that a child does have independent advocacy, unless, of course, the child, him or herself, opts not to have it. However, all of that said, I do recognise that these issues are extremely complex. I also recognise and accept, and I've had this conversation with the Minister, that there are concerns about a possible two-tier approach to advocacy, where some young people have it on an opt-in basis and others have it on an opt-out basis. On that basis, and taking account of the comments that I have heard from the Minister, and I should say I recognise that the Minister is not able to bind her successor, nevertheless, if the Minister was able to give a commitment today on behalf of the Government that its intention would be to consider the effectiveness of advocacy overall, and indeed that would encompass some of the amendments passed earlier, but in particular to look at this issue of opt-in or opt-out in the wider review of the Act. I would be minded not to press my amendments in this group today, and therefore I'll listen carefully to the Minister's comments and indeed to the wider debate. However, all of that said, I will move 169 at this stage because I understand that is required to allow this debate to proceed.
Thank you. And I call Martin Whitfield to speak to Amendment 185 and other amendments in the group.
I'm very grateful, Presiding Officer, and I'm very grateful for the member for moving her amendment so that we can discuss this group. I think we have already understood the challenge that exists between opting in and opting out, and we clearly have not reached a consensus on this. I would agree with the previous contribution that a resulting two-tier system may potentially be the worst of all worlds that we find ourselves in. So my amendments 185, 187, 190, 193, 196 to 198 seek to introduce an opt-out system for advocacy, because this was a key ask of Hearings for Children. It has been called on by voices from across the care sector for a long, long time. 93% of care-experienced people. Independent advocacy is a vital tool for care-experienced children and young people to have their voice listened to. A group who for far too long are left voiceless and marginalised. And we know that this makes a practical difference in the lives of young people. Social Work Scotland, BASW, have raised concerns about the dangers of introducing uncosted measures into an already struggling system, which bear relevance for advocacy provision. But we must ensure that whatever measures we introduce in this bill or subsequent are properly funded. And arguments about the cost of the opt-out model advanced by the government earlier on, with all respect, I do not believe hold water. The Scottish Independent Alliance on Advocacy estimates that for every £1 that's invested in advocacy services, £12 are saved in other areas. And I understand the discussions that have been happening and the assurances that have been indicated. I think of all of the amendments, of all of the sections that we've faced in this, this is the one where I think the Minister is potentially most challenged, because as we saw occurring in stage 2, the then votes indicated a desire to see things on the bill that could subsequently be changed. We do not have this privilege at stage 3, but I do absolutely accept the Minister and will take her on her word, albeit that rightly you cannot bind future governments. But a commitment to sort this out, I think, is essential. I think the commitment has to be plain, simple, and the vehicle for doing that is almost as soon as the next session starts with regard to the provisions that are coming in this bill to allow the review. We are not going to solve this afternoon, but I think that the government can show a way that this matter can be resolved where people on both sides of the argument can come together. We can find common ground where it exists, however that is articulated. But most of all, we can ensure that those marginalised and forgotten voices do not suffer that longer than they need to. So I wait with interest to hear what the Minister says. I'm grateful, Presiding Officer.
Thank you. I call Rose McCall to speak to Amendment 78 and other amendments in the group.
Thank you, Presiding Officer. I think we're all of one voice here. My amendment was to move towards an opt-out model. For all the same arguments that have been so eloquently put forward, I understand the issues that there are surrounding this. But I think it highlights this evening that at all areas of the Chamber we are aware of the issue, and that children have to have that voice that they so desperately need in this case. I'm not going to add too much more. I'm very interested to hear what the Minister will come back and say. We all were of agreement that there needs to be more done in this sphere, so I wait with bated breath to hear what the Minister say. Thank you.
Thank you. I call Ross Greer to speak to Amendment 200 and other amendments in the group.
Thank you. Amendment 200 would change Section 122 of the Children's Hearing Scotland Act of 2011. That's the section that makes provision for advocacy services to assist a child in relation to their involvement in a children's hearing. 200 amends the definition of children's advocacy services in subsection 7 to clarify that those services can still be provided where a child is unable, due to age or capacity, to instruct that such services are provided to them. At stage 2, I agreed not to move my amendment on non-instructed advocacy, as it's known, in agreement with the Minister, so that we could work on an agreed solution ahead of stage 3. There's been strong cross-party interest in strengthening children's independent advocacy provision and representation. This amendment clarifies that the provision of children's advocacy services in relation to these hearings can include non-instructed advocacy. This will ensure that all children's rights are upheld in children's hearings, especially those who are unable to indicate for themselves that they wish to be provided with advocacy. I do also wish to touch briefly on the amendments in this group that have been lodged by Nicola Sturgeon on opt-out referral to advocacy, which I have supported, and the equivalent amendments from colleagues. Like everyone else, I acknowledge that this is an area where balancing rights is tricky, particularly in relation to privacy rights. But I am worried about those who fall through the cracks for the reasons that Nicola Sturgeon outlined a moment ago. My amendment on non-instructed advocacy in relation to hearings is one very specific safeguard against that. But I still believe that an opt-out rather than opt-in system is the closest that we can get to ensuring that no child or young person falls through these cracks, while preserving their right to make the choice for themselves where they have the capacity to do so. So I would echo that ask of the Minister. If the Government will consider the effectiveness of advocacy and this specific question, we know that there will need to be a further bill in this area in the next session of Parliament. That bill could be an opportunity, I believe it must be an opportunity, for us to revisit this question once the Government has conducted further work to explore what our options are. At this point, though, I would very much be inclined towards an opt-out rather than opt-in system, but I recognise that's not something that Parliament will be able to proceed with at this stage.
Thank you, and I call the Minister.
Thank you, Presiding Officer. I thank members for explaining the intent of their respective amendments in this group. I welcome Ross Greer's Amendment 200, which clarifies non-instructed advocacy provision for children's hearings, and encourage members to vote for that. I also support Martin Whitfield's Amendment 197, which strengthens the obligation of the chairing panel member to connect children with advocacy services. However, there are issues with the framing and drafting of the remaining amendments in this group, which mean I cannot support them. At a basic level, in different ways and at different points, the amendments seek to change the advocacy for children in the hearing system model from opt-in and demand-led to a model of opt-out. And I've listened and I understand and I respect the competing perspectives on this issue. I would maintain that at this moment, legislating for an opt-out model is not right, due to some of the challenges that have already been touched on by members, and I'll further explore in my comments. The current approach, operating well for more than 5 years, is not just opt-in, it is opt-in and demand-led. We have repeatedly uprated and have now nearly doubled levels of provision since the scheme's introduction in 2020. I want to see more children and young people benefit from advocacy through this bill and related activity. We've already expanded provision to meet growing demand for children. We should continue to do so. Other changes in the bill will help us increase awareness and take-up by ensuring earlier and broader signposting by statutory bodies, engaging with children and making referrals to the Children's Reporter. I know members want assurance that those measures are proving effective in boosting uptake rates and in connecting more children with advocacy opportunities. The post-implementation review and reporting arrangements should track and monitor whether opt-out needs to be revisited, and that should happen in good time to allow any further or required changes to be implemented within the promise-keeping timeline. And I think we can do that work with justified confidence. The existing national practice model was co-designed with advocacy providers and children's organisations. It empowers children to make informed choices. Repeated offers of advocacy are already made, and children can change their mind at any time. It offers choice of 2 fully funded advocacy organisations in each local authority area to a child to manage conflict of interest and promote choice and continuity in pre-existing relationships. Making an automatic referral to one state-selected provider removes some of that choice and control from children, two issues that continue to matter to them. And as I reported at stage 2, children have told researchers they want to be the boss. Opt-out takes that empowerment away from them. Choice is key. It means that children can ask for advocacy support at any point in their engagement with the children's hearing system. Unfortunately, Amendments 169 and 170 would create a fixed point at which children must receive advocacy. So essentially, I'll take Mr Rennie's amendment. Not amendment, sorry.
I've been persuaded by the Minister on the benefits of an opt-in system, but surely the test of all of this is what the Minister has referred to, which is the take-up in the longer term. And we need to measure that at every single stage, because if we aren't sharing the information, if we aren't encouraging young people to take up the service, we will need to come back and look at this again. But for now, I am a supporter of the opt-in service for the reasons that the Minister set out.
Minister.
I thank Mr Rennie for setting that out, and I was just getting to my sort of summary of that section, in that absolutely I feel like this needs to be monitored, to be considered again in a future Parliament, to understand if that opt-out service is appropriately working for our children and young people. So I would look to come back to this, and I will take Mr Greer's intervention.
Ross Greer.
Thank you. I'm grateful to the Minister for taking the intervention. Just following up on Will Rain's points around monitoring uptake, could I just emphasise to the Minister, and I hope she would agree, that it's not just about overall uptake rates. We know that when advocacy is offered to young people, 98% of them take it up. What we should be really focusing on are the 2% who do not, and the reasons why they've not taken it up. In some cases, it might be a perfectly legitimate choice that they have made for themselves. In other cases, though, it is the most marginalised young people in the system, and those are the cases in which we really need to consider whether an opt-out model is necessary.
Minister.
I think Mr Greer makes an excellent point, and it is that small, perhaps minority of young people who are not taking on that advocacy offer that we absolutely need to understand why. So I recognise the intention behind Amendments 186, 188, 191, 194 and 198, but the founding co-branding principles of our children's hearing system recognise there is often a blend of issues in a child's life across justice and welfare grounds. The entire ethos of the system is founded in that recognition that an integrated approach remains the right one. Scotland deals with deeds by addressing needs. These amendments assume a clear distinction between the advocacy needs of children being referred on justice grounds and those dealt with on welfare grounds that often does not exist. And I know this point was highlighted by Ms Sturgeon, essentially ending up in a two-tier system. I don't think it would be right to split children into different entitlement groups based only on the legal ground of referral. I acknowledge, of course, that upcoming Care and Justice Act reforms will bring more older children into the hearing system. Taking more children's offences out of our courts will be challenging. The modernised hearing system needs to be able to respond credibly and effectively to older children's deeds, some of which will be serious. And I expect the new remunerated chairing panel member to bring more profile to these issues. I am also aware that the consistent application of children's advocacy entitlement needs to be better, and I look to all agencies and system leaders to ensure that that happens and to assist us when we look again at opt-out questions. These reforms mean that advocacy, rights and voice supports, especially for older children, should be broadened and strengthened, and as I have indicated, we will meet that need as it emerges. Advocacy is not a replacement for legal representation. Both need to be available and complement each other where required and appropriate. And that's why the need for legal representation is already available for many of the cases addressed by the amendments. We're also strengthening the legal offer to children involved with offence referrals elsewhere in this bill. I really do welcome the opportunity to debate the best way to take forward support for the children who will be served by the redesigned hearing system. However, for the reasons set out above, I cannot support Amendments 78, 185, 187, 190, 193, 196, 199, 169, 170, 186, 188, 191, 194, 198. If members press them, regretfully, I do ask members to vote against them. However, I do support Ross Greer's Amendment 200 and Martin Whitfield's 197, and I encourage members to vote for them.
Thank you. And I call Nicola Sturgeon to wind up and press or withdraw Amendment 169.
Thank you, President Officer. I think this has been a really helpful debate. I certainly recognise the points that the Minister has made. I also readily accept that there are technical issues with my amendments, and I think she set them out very well. Look, I am in principle in favour of an opt-out approach, but I recognise that we are not in a position to move to that generally today. I also concede, and the point I think has been made by Willie Rennie, Ross Greer and indeed by the Minister, that if the take-up rates around an opt-in approach are sufficiently high, then it may be possible to persuade me and others that that is the right approach and an opt-out alternative is not necessary. I think that remains to be seen, and therefore I think monitoring of that will be extremely important. I also accept that my amendments in seeking in good faith a compromise might actually raise more issues than they solve, and I should say to the Minister that a reference to Kilbrandon will always be highly influential with me, so that was well targeted. I think in light of the Minister's comments, the wider debate and the assurances that she has given, I will not press Amendment 169 and give notice that I don't intend to move the other amendments in my name in this group.
Thank you. Nicola Sturgeon seeks to withdraw amendment number 169. Does any member object? No member objects and the amendment is withdrawn. I call amendment 170 in the name of Nicola Sturgeon, already debated with amendment 169. Nicola Sturgeon to move or not move?
Not moved.
Thank you. And I call amendment 55 in the name of Jeremy Balfour, already debated with amendment 48. Jeremy Balfour to move or not move?
Not move.
Thank you. We move on to Group 18, Children's Hearings, Timescales. And I call amendment 171 in the name of Martin Whitfield, grouped with amendments 181 and 182. Martin Whitfield to move amendment 171 and speak to other amendments in the group.
I'm very grateful, Presiding Officer. And as has already been outlined extensively in relation to the permanent amendments, drift and delay in decision-making within the children's hearing system can be extremely harmful to the development of young children in particular. The 3-month time frame proposed in this amendment, argued for by Hearings for Children, is based on evidence, because after this point, instability in the lives of young people becomes increasingly harmful. The evidence from England and Wales, where there is a 26-week time limit for care proceedings, tells us that a blanket ideological opposition to time limits is not based in reality. And we know that the measures that exist south of the border are working. We know that children in Scotland are forced to wait longer, and we know that change must happen. Amendment 171 provides scope to extend the time limit in exceptional circumstances, but it would help embed a culture which does not tolerate drift or delay. So my amendment seeks to achieve that. The other amendments that appear in this section in 181 and 182 in the names of Bill Kidd and Ross McCall. I look forward to hearing from you, from the members on that, because we are all dealing with the same challenging problem, that one of the most pernicious challenges is where delay happens in a young person's life. And when it happens in a baby's life or an infant's life, which we will get onto, the damage can, and sometimes, and only too frequently, is catastrophic. So I look forward to hearing from the Minister on the position of the Government with regard to timescales, which I know we battered between us during stage 2, and it will be interesting to see where that's got to. So for the purposes of debate, certainly I will move Amendment 171.
Thank you. I call Bill Kidd to speak to Amendment 181 and other amendments in the group.
Thank you very much, Presiding Officer. I'm pleased to have the opportunity to make a contribution to this seminal bill and what is the last piece of government legislation I'll have the privilege of seeing this Parliament pass into law before I retire as an MSP. Amendment 181 will place timescales on the establishment of grounds before a sheriff, as was just mentioned. Currently, a court must hold a hearing within 28 days of the application for proof of grounds, and this amendment will put in place an additional timescale of 90 days for a decision to then be made on the establishment of those grounds. The 90-day period will be from the point at which the application for proof is made by the principal reporter to the court. Sheriff Mackey, in his Hearings for Children report, specifically stated that the benefits of this approach should be explored, and I thank colleagues, specifically Martin Whitfield, for bringing forward amendments at stage 2 on this topic. However, in bringing forward this amendment, I am mindful of the need to ensure that any provision in this space is properly directed and addresses the root of any issue. We must also recognise that the role of managing any case before the court is a matter for the Sheriff, and I thank the offices of the Lord President and those of the Sheriff's Principal for their engagement with the Government on this topic since stage 2. The issue of establishing the grounds in a timely fashion is key to an effective and efficient system operating as best it can for children and their families. Cases which can be prolonged are often done for good reason, but this amendment will ensure that there is appropriate and effective judicial oversight, and that cases will only go beyond the timescale where it is appropriate and necessary to do so, having regard to the best interests of the child who is the subject of the referral. We are all keen to ensure that cases are dealt with effectively and efficiently, minimising delay and ensuring no child or family are unnecessarily waiting for decisions to be taken or actions to be implemented. And I urge members to support Amendment 181. Thank you.
Thank you. I call Ros McCall to speak to Amendment 182 and other amendments in the group.
Thank you, Presiding Officer. I am pleased to bring forward Amendment 182. Members will recall that we discussed the need for measured timeliness in the children's hearing system at stage 2. We agreed that we should do so in a refined, future-proof fashion. So I initially lodged Amendment 198 on waiting times, and I agreed to withdraw it so I could work on the strengthened provision that we have before us in Parliament today. And I want to thank the Minister for her engagement on this, because the Minister advised the committee colleagues at stage 2 that there was existing work setting out standards and reporting expectations on timescales for the relevant steps in the current children's hearing system. And this amendment aims to build on that good work, extend it and update it. The policy intention and legal effects of this new amendment is that the reporting obligation must be given to ministers, given the cross-system multi-agency scope. It will require ministers to prepare and publish an annual report, which will also be laid before the Parliament. We shall all share the desire for enhanced future transparency in terms of how the modernised children's hearing system is actually performing in responding in a timely way to support the children who are referred. The core system partners recognise the need to address delay and have established an effective but partial mechanism in the current system. An updated, extended and sustainable scheme will enable Scotland to measure performance, to pick out areas for improvement. And this amendment puts timeliness reporting on a statutory footing and future-proofs it. And I hope that will attract the support of members across the chamber. Thank you.
Thank you. I call the Minister.
Thank you, Presiding Officer. Martin Whitfield's Amendment 171 speaks to our continuing interest in efficient and timely decision-making in the children's hearing system. We all want to see grounds established in a timely manner without unnecessary delay. Since stage 2, there have been further discussions with key agencies and representatives, including the Office of the Lord President, the Scottish Courts and Tribunals Service and Sheriff Principals. Those discussions have made plain a shared desire to continue to work to address drift and delay where it occurs, but that the creation of statutory timescales would be unhelpful to achieving improvements and risk compromising the ability to treat the most complex and sensitive cases with the scrutiny and consideration they deserve. Bill Kidd's Amendment 181 achieves Mr Whitfield's objective and I think better reflects the outputs of those intervening discussions. This amendment will reinforce or set out appropriate timescales for hearings in relation to the grounds, whilst allowing appropriate discretion for the Sheriff. There are some circumstances where timescales will necessarily require to be extended, and that can be for a variety of reasons. The discretion inherent in the provision will ensure this will only happen where the Sheriff has had regard to whether this would be in the child's best interests. Applications will be dealt with in as timely a manner as is practical. Presiding Officer, if I may, I want to thank Bill Kidd for agreeing to lodge this amendment and for his long commitment to issues of fairness and justice during his parliamentary career. Bill has always championed the interests of those with the greatest need in his constituency and in Scotland, and I think this small but important amendment is entirely in keeping with his values and feels like a good way to sign off on Bill's contribution to legislation in this Parliament. I hope Martin Whitfield will agree that Bill Kidd's Amendment 181 achieves a similar objective and will not press his amendment. And I thank Ros McCall. We'll keep the good favour going. I thank Ros McCall for lodging Amendment 182 concerning the future national and local reporting of timely decision making. It reflects positive joint work with the Government on our shared objectives on this topic, and I support it. I therefore encourage members to support Amendments 181 and 182 and to resist Amendment 171 if pressed.
Thank you. And I call Martin Whitfield to wind up and press or withdraw Amendment 171.
I'm very grateful, Presiding Officer, and it is perhaps just by chance that it allows me to add to the Minister's very kind comments to Bill Kidd, who may or may not remember this, was in fact the first colleague across this chamber to say hello to me when we came in the heady starts all those years ago, and has continued every day at the very least to ensure that my health is in good keeping, and for that I will forever thank him. But I would also like to echo something picked up by the Minister, that actually when Bill Kidd does contribute to both in committees and here across the chamber, it is always for the smaller and the quieter voice that he makes sure is heard, and I think people outside of this place will be forever grateful for that. So thank you. As to the courtesy, as to the courtesy that the Minister invites me to do on the back of the compliment to an excellent amendment lodged by Bill Kidd, I think it's perhaps easiest to say I have no challenges in supporting your brilliantly drafted amendment, and on the basis that actually we are starting to address a very significant problem both with Bill Kidd's amendment and indeed with Ros McCall's. I will seek to withdraw Amendment 171.
Thank you. Martin Whitfield seeks to withdraw Amendment number 171. Does any member object? No member objects, and Amendment 171 is withdrawn. We move to Group 19, Children's Hearings, Infants. I call Amendment 172 in the name of Martin Whitfield, grouped with Amendments 173, 174, 183 and 184. Martin Whitfield to move Amendment 172 and speak to other amendments in the group.
I'm very grateful, Presiding Officer, and it is by simple revenge I get to stand and rise and can return the compliments to the Minister, who I hope will find full support for all of my brilliantly drafted amendments, 172 through to 174. And on a serious note, well, a serious note that I'm sure the Government will accept these. On a serious note, the question of young children, and let's be honest in language, babies, is very important within the care-experienced communities. I have spoken to a number of people who, both subjectively and objectively, find a challenge in that all of our young people are labelled the same. And in doing so, we do a great discourtesy to our babies who cannot express their own voice and rely on others to do so, to our young children who are developing and are often confronted with incredibly complex questions for which their long-term understanding of decisions that are being made about them is at the very least patchy. And the reality is, as most of us will testify here too, you get to an age where you remember nothing about what you did before 5, other than what is perhaps shown to you in photographs. So the purpose behind Amendments 172 and 174 is to indicate the need for a different approach with regard to babies and infants. It's a practical approach to avoid any unnecessary delay to proceedings before hearings. And as I've detailed already this afternoon, it is absolutely vital for the developmental integrity of young children, babies and infants to be preserved. So the amendments in my name in this section seek to place an age limit in respect of decisions and circumstances. I know this is challenging for the government to find favour with, so I'm not expecting miracles today. However, I do think that for those who represent the voice of babies and infants, and indeed for those babies and infants who at this stage are tiny but will grow up and will come to understand the decisions that have affected them, it is important that both this Chamber, this Parliament, this Scottish Government, but most of all for the purposes of the promise and the care experience system, we recognise that they are a very, very special case within a group of very, very special people. And so with that, I look forward to hearing from the Minister and others within this group. I'm grateful, Presiding Officer.
Thank you. And I call Ros McCall to speak to Amendment 183 and other amendments in the group.
Thank you, Presiding Officer. The situation that we have with infants within the children's hearing system is a very important one to me and to many people within the Chamber. They're among the most vulnerable members of our society, and has already been alluded by Mr Whitfield, their developmental stage and the issues that going through a care process has on their development is most profound. They cannot speak for themselves, but every decision we make affects them greatly. So in Amendment 183 introduces the role of an infant safeguarder, a dedicated advocate to ensure that even the youngest children have someone who understands their needs and speaks up for them and ensures that their voices are not lost in the process. An infant safeguarder's remit would be standardised to represent the infant's lived experiences within their caregiving relationship throughout their engagement with the hearing system. It involves gathering information from the important people in the child's life and being automatically appointed for all infants under 5 upon referral to the reporter. An infant safeguarder's role is to represent the infant's best interests, as I've already said, throughout the whole process, attending hearings and monitoring where services are being provided as planned. It is a shift, but it is a monumental one, and one that I would hope we could have agreement on. Amendment 184 builds on the last amendment, but goes further by requiring that infants in the children's hearing system have a specialist representation. The earliest years of life are critical. Attachment and development and emotional security all hang in the balance. Too often the needs and the experiences of infants are overlooked simply because they cannot articulate them to us in words. And by assuring that infants have formal representation, we guarantee their unique needs are not forgotten, and their best interests are always placed at the centre of our decisions. These views, Article 12 of the United Nations Convention on the Rights of the Child makes it clear there is no lower age limit for the obligation to consider children's views in decisions that affect them. Those views are not just what is spoken, they include non-verbal cues and behaviours, and this amendment ensures that specialist arrangements are made to understand the communication and communicate infants' views and experiences, and I urge the Chamber to support these amendments. Thank you.
Thank you. I call the Minister.
Presiding Officer, we can all agree on the importance of ensuring that the needs and interests of babies and infants are properly represented and fully met and supported through the children's hearing system. Where we might disagree is on how best to achieve that, and I don't consider the amendments in this group the appropriate way to do so. And I note that the Promise Scotland were not supportive of similar amendments lodged at stage 2. If we're trying to take forward a rights-based approach centred on children's individual needs, that makes the very idea of creating distinctions based solely on age challenging. I understand the intent behind Martin Whitfield's amendments 172, 173 and 174, and I thank him for laying them and allowing us to debate this matter. However, in line with the UNCRC, recent reforms made by this Parliament, such as the Children Scotland Act 2020, have moved away from arbitrary presumptions or distinctions about a child's capacity based purely on age. There is a risk that introducing such an age-based approach might lead to unlawful discrimination, contrary to Article 14 of the ECHR. I consider the current approach, which takes into account the individual needs of each child, as the better way to approach matters, and I hope Martin Whitfield agrees and will not press these amendments. I thank Ros McCall for explaining the rationale behind her Amendment 183. However, there are technical flaws in it. The National Convener has no role in safeguarder appointments. Ministers appoint safeguarders. The operation of the National Safeguarder Panel and their allocation to cases is organised under contract currently by Children First. That panel was established under the 2011 Act and is a fully demand-led specialist service available for any child where there is an identified need. Safeguarders are already very often appointed to younger children, including babies and infants, and the system works well. I therefore do not see the need for a bespoke service or type of safeguarder for infants. However, I acknowledge that there is always more we can do to ensure that the rights, needs and interests of very young children are met in the children's hearing system. The Scottish Government will therefore work with Children First to further strengthen the training available on working with very young children. This will be directly informed by the support and expertise to be offered to panel members through upskilling work led by NSPCC in partnership with Children's Hearing Scotland. Similarly, I also don't see the need for an infant advocacy service for under 5s as proposed in Ros McCall's Amendment 184, and I note that this was not an improvement recommended by the Hearings for Children report. This is an extremely emotive subject, and I recognise that we must do all we can to promote and protect the particular interests and needs of babies and infants in the children's hearing system, and that's why the Children's Hearing Redesign Board is establishing a dedicated infants and babies work stream, as I alluded to earlier. I hope members will agree that this is the right approach to this issue. I would ask Ros McCall and Martin Whitfield not to press their respective amendments. If they do, I would encourage members to vote against 172, 173, 174, 183 and 184.
Thank you, and I call Martin Whitfield to wind up and press or withdraw Amendment 172.
I'm very grateful, Presiding Officer. We find ourselves, I think, in the same position that we did at the end of stage 2, and I understand the arguments from the government, and I understand their reliance on the dedicated infant work stream. And this is a challenging area because we have a system at the moment that, as you read through it, requires the additional reassurance for infants and babies to come from interpretation of what is being said. That, notwithstanding that, I do have confidence that the dedicated infant work stream, given who is involved in it, will see changes develop. I fear the changes may well be not dissimilar to what's being articulated in these amendments, but given the situation with regard to the opt-in, opt-out situation and the fact that the dedicated infant work stream is working on this occasion, I will again take both the confidence in what the Minister says, but also the assurance that obviously the Scottish Government, whoever sits in that position, will have the feedback from the work stream coming, and I will seek to withdraw Amendment 172, Presiding Officer.
Thank you. Martin Whitfield seeks to withdraw Amendment number 172. Does any member object? No member objects, therefore Amendment 172 is withdrawn. I call Amendment 56 in the name of the Minister, already debated with Amendment 48. Minister to move formally.
Moved.
Thank you. The question is that Amendment 56 be agreed to. Are we all agreed? We are agreed. I call Amendment 173 in the name of Martin Whitfield, already debated with Amendment 172. Martin Whitfield to move or not move?
Not move.
Thank you. I call Amendment 57 in the name of the Minister, already debated with Amendment 48. Minister to move formally.
Moved.
Thank you. The question is that Amendment 57 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 58 in the name of the Minister, already debated with Amendment 48. Minister to move formally.
Moved.
Thank you. The question is that Amendment 58 be agreed to. Are we all agreed? We are agreed. I call Amendment 174 in the name of Martin Whitfield, already debated with Amendment 172. Martin Whitfield to move or not move?
Not move.
The amendment is not moved. I call Amendments 59, 60, 61, 62, 175, 176, 177, 63, 64, 65, 66, 67, 68, 69, 70, 71 and 72. all in the name of the Minister and all previously debated with Amendment 48. I invite the Minister to move amendments 59 to 62, 175 to 177 and 63 to 72 en bloc. Thank you. Does any member object to a single question being put on amendments 59 to 62, 175 to 177 and 63 to 72? No member objects. Therefore, the question is that amendments 59 to 62, 175 to 177 and 63 to 72 are agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 73 in the name of the Minister, already debated with Amendment 48. Minister to move formally.
Moved.
Thank you. I call Amendment 73A in the name of the Minister, already debated with Amendment 48. Minister to move formally.
Moved.
Thank you. The question is that Amendment 73A be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 73A in the name of the Minister is yes 97, no 16. There were no abstentions. The amendment is therefore agreed. Minister to press or withdraw amendment 73 as amended.
Sorry, Presiding Officer, I missed.
Sorry, Minister to press or withdraw amendment 73 as amended.
Pressed.
Thank you. The question is that amendment 73 as amended be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 73 as amended in the name of the Minister is yes 96, no 18. There were no abstentions. The amendment as amended is therefore agreed. I call amendment 178 in the name of Martin Whitfield, already debated with amendment 48. Martin Whitfield to move or not move? The question is that amendment 178 be agreed to. Are we all agreed? We are agreed. I call amendment 179 in the name of Martin Whitfield, already debated with Amendment 48. Martin Whitfield to move or not move?
Move.
The question is that Amendment 179 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 180 in the name of Martin Whitfield, already debated with Amendment 48. Martin Whitfield to move or not move?
Move.
The question is that Amendment 180 be agreed to. Are we all agreed? Yes. We are agreed, and we move to Group 20, Children's Hearings, Legal Advice and Representation and Legal Aid. I call Amendment 74 in the name of Jeremy Balfour, grouped with Amendments 75, 77, 189, 192, 195 and 201. Jeremy Balfour to move Amendment 74 and speak to other amendments in the group.
Thank you, Presiding Officer. Presiding Officer, the good news for the Chamber, these are my last amendments that I will be speaking to tonight and actually, hopefully, in regard to this particular session. 74 in my name and 75 in the name of Ros McCaw look to do similar things, and I do hope that the Government might be willing to look at one of our amendments in regard to this. This amendment follows recommendations laid out in the Children's Hearing Review, where we recommended that there should be consideration of the development of rights of audience, where lawyers should demonstrate certain skills and attributes before being able to appear on behalf of children and relevant people at a hearing. This amendment therefore states that solicitors have a right to audience at a children's hearing only if the solicitor meets certain requirements, such as approved training course on child-centred trauma-informed practice. The amendment also states that the Council of the Law Society of Scotland must also keep public record of solicitors who have passed this training and therefore have a right of audience in children's hearings. This will allow training to be given which will ensure lawyers and particular solicitors act in a way that is accessible, understandable and not overtly adversarial. There is already precedent set for this type of training being required for specific hearings, for example, the rights of audience introduced for sexual offenders courts. Now, I understand the Law Society are not supportive of this amendment. They point out that there is no training for advocates, but that is simply because it is so rare for advocates ever to appear at such hearings. And secondly, they say it will take time for this to happen, and I accept that. But I do think, as we go forward with these hearings, it is important that the families and children and the panel members are addressed by those with the appropriate training. And so I do think it is possible to do it, and I think having a child-centred and trauma-informed manner is really important. Thus, I would urge members to accept my amendment or to accept the amendment in Ros McCaw's name. Amendment 77 defines child-centred legal advice and representation. This amendment was brought to my attention by the leading children's charity Clan Child Law, and I want to put on record my thanks to them for their assistance, not only with this amendment, but with them helping me understand this bill better. There's a lot of talk, and we are absolutely right talking about child-centred approach in this bill, which is welcome and has to be the right direction for legislation being taken forward. But I suspect if we went round the 128 members and asked what is child-centred, we would all come up with slightly different definitions. And there is no central approach in regard to this. And thus, when it comes to legislation, it is difficult to define if it's passed into law. This amendment relates specifically to Section 18, where local authorities must provide the child in question with information on what is going to happen with regards to the hearing process. The availability of child advocacy services and the availability of child-centred legal advice and representations. In discussions with Clan Child Law, I felt the phrase child-centred legal advice and representation should be defined in secondary legislation brought by Scottish ministers to ensure it is understood and complies with the good intentions of the bill. These regulations will then be subject to the affirmative procedure to ensure Parliament is happy, and I ask that people consider these carefully. Amendments 189, 192 and 195 are additions and clarifications to Stage 2 of this bill when Amendment 115 was passed in my name with regards to ensuring children are aware of their rights to legal representation. At Stage 2, Amendment 115 was specifically drafted with regards to when the local authority is given the principal reporter information about the child with regards to children's hearings, and the local authority must, at this time, inform the child about what will happen in relation to this referral. The children's hearing process in general and the availability of children's advocacy service specifically. Amendment 115 added a further clause to ensure at the same time children were also given information about the availability of child-centred legal representation and advice. This was passed unanimously by the committee at Stage 2 with the Minister's backing. But it's come to my attention that this additional clause needs to be expanded so it not only applies to when a local authority refers a child to a principal reporter, but in other referral situations as well. So Amendment 189, 192, 195 ensure that children will be made aware of availability of child-centred legal representation and advice, however they are referred. Amendment 189 ensures that if a constable makes the referral, Amendment 192 amends to ensure if a health board makes the referral, and finally Amendment 195 when the principal reporter informs the child that they need to make a determination in relation to that child. Now, I understand from the Minister's correspondence with me that she doesn't believe that these amendments are necessary. I have to say both the Law Society of Scotland and Clan Law disagree with that. Now, with due respect to you, Deputy Presiding Officer, you will appreciate that if you have 4 solicitors, 4 lawyers in a room, you will get 12 different answers. Now, the Minister said these aren't necessary. Obviously, other legal opinion disagrees with her. Now, the Minister does concede that we don't do any harm, so I would still ask the Government to accept these amendments because it would absolutely clarify the situation and leave things not in any doubt at all. Finally, you'll be glad to hear, Deputy Presiding Officer, I want to speak to Amendment 201. I do thank the Minister and her team in regard to this, and this simply aims to enhance existing automatic legal aid provision for children involved in the children's hearings system. It will guarantee, I think really importantly, the availability of automatic legal aid in cases where a child is referred to the children's reporter in respect of an offence that would likely have been prosecuted or indictment that the PF decided to pursue a conviction. I think this is a very helpful move forward, and I again thank the Minister for her help in regard to drafting Amendment 201, and I look forward to the members accepting all my amendments in my name. Thank you.
Thank you, Mr Balfour. I call Ros McCall to speak to Amendment 75 and other amendments in the group. Ms McCall.
Thank you, Deputy Presiding Officer, and you'll be glad to know this is the last time I'm speaking as well this evening. And I do align myself with the comments made by Jeremy Balfour, especially regarding his Amendment 74. My Amendment 75 seeks to ensure that children are supported by appropriately skilled legal representatives. They're put in a unique environment, in a unique situation, and representing a child within that environment requires more than just general legal knowledge. And my amendment introduces an accreditation requirement for solicitors, ensuring those representing children have the necessary skills, experience and understanding of what is asked of them. It is about raising standards and ensuring that children receive representation that is effective, informed and tailored to their needs. For a child, having the right support in that setting can make a significant difference to their experience and to the outcomes. And I don't want to over-egg the pudding, so I urge members to support the amendment. Thank you.
Thank you, Ms McCall. I call Willie Rennie.
I want to talk to Amendments 74 and 75. I understand the Minister has concerns about how these would be implemented, and we've already heard about the Law Society's concerns as well. So it is a sensitive area where the Government needs to act cautiously. However, we shouldn't forget what was said in the promise. It said everyone involved in the children's hearing system must be properly trained in the impact of trauma, childhood development, neurodiversity and children's rights. This was echoed in recommendations from the Hearers for Children report, including this comment: there must be consideration of the development of rights of audience, so that lawyers should demonstrate certain skills and attributes before being able to appear on behalf of children and relevant people at a hearing. These recommendations were wholly or partially accepted by the Government at the time. So I want to hear clearly from the Minister in her remarks that if these amendments 74 and 75 aren't workable, then what other work is the Government taking forward to meet this aspect of the promise and the recommendations for the Hearings for Children report? If I can be given that confidence, I won't support these amendments.
Thank you, Mr Rennie. I call the Minister.
Thank you, Presiding Officer. Jeremy Balfour's Amendments 74 and 77 and Ros McCall's Amendment 75 are based on similar ones lodged at Stage 2, and I undertook then to engage further with stakeholders and consider them further. As we know, in Scotland, the regulation of solicitors is for the Law Society of Scotland, overseen by the Lord President. At Stage 2, I highlighted that Minister-driven accreditation would represent a significant departure from that long-standing position and risk impinging on professional independence, a concern that I raise again today. That concern is also shared by the Lord President and indeed by other legal stakeholders. While I fully endorse trauma-informed practice, placing approval for solicitors out with the independent regulatory framework would be inappropriate. I therefore cannot support Amendment 74. While Amendment 75 includes consultation and would be subject to the affirmative procedure, it still moves accreditation into a ministerial responsibility, and I cannot support that either. The phrase you... Yes, I'll take a...
Jeremy Barr.
I accept it is unusual, but we have done it on other pieces of legislation. So why was it okay to do it when lawyers had to appear in regard to sexual offences, and it's not right to protect vulnerable children in this way?
Minister.
It's not about whether it's not right to protect vulnerable children in this way. I've laid out, the advice that I have received, the comments and the opinions by the Lord President, the Law Society of Scotland. I can't speak for other decisions that have been made, but in terms of my approach, I believe that this is the best way forward. And I'm going to speak to, I hope some assurances that Mr Rennie is looking for, that I hope will also provide Mr Balfour with assurance in terms of how government will take this forward. So the phrase used in Amendment 77, legal advice, is not routinely defined in statute. However, its meaning is well established through practice, and a statutory definition risks limiting its meaning. Moreover, creating a statutory definition without a requirement to consult relevant bodies also risks cutting across the existing regulatory framework, where the Law Society of Scotland and the Lord President set and oversee standards of competence and professional duties. I would also assure members that there are safeguards in place already. The Scottish Legal Aid Board already requires solicitors working in the area of children's legal assistance to meet 5 defined standards which demonstrate their knowledge and experience in child law and development. Solicitors can also choose to be specially accredited in child law through the Law Society of Scotland, and many do. Our response to the Hearings for Children review noted that it was a matter for the Law Society of Scotland and the Scottish Legal Aid Board to ensure the highest of standards for those providing advice and representation to children. However, I will commit to writing to the Lord President, the Law Society of Scotland, the Scottish Legal Aid Board and the National Convener to ask them to consider what further training may be required to be made available for solicitors appearing at children's hearings, in addition to meeting the already high standards already set out by the Scottish Legal Aid Board. I would therefore encourage Jeremy Balfour and Ros McCall not to press their respective amendments. I welcome Jeremy Balfour's amendments 189, 192 and 195, but I can assure him that they are unnecessary, largely because the duties that they seek to create are already provided for. Rule 23A of the Children's Hearing Scotland Act 2011 Rules of Procedure 2013 requires the principal reporter to give every child and relevant person information about the availability of legal advice whenever a hearing is convened. That obligation is clear, it is mandatory and it is already in force. Extending this duty to other referring agencies is unnecessary because legal advice only becomes relevant once the reporter decides that a hearing should proceed. Section 18(2) of the bill distinguishes local authorities because, unlike most other referring bodies, they will usually have ongoing involvement with the child and family once a referral has been made. They are therefore well placed to raise awareness of legal aid and of advocacy services in the period leading up to and following the reporter's decision. In addition, anyone who is in police custody or attends a police station, either voluntarily or for police interview, has a right to legal advice and to have a solicitor present in an interview. The right to have a solicitor present at interview cannot be waived by a person aged under 16, by a person 16 or over who appears unable to understand what is happening or communicate effectively, or by a person of 16 or 17 who is subject to a compulsory supervision order or an interim such order. A person of 16 or 17 not subject to either of those restrictions can waive that right only if a relevant person, as defined in section 33(5) of the Criminal Justice Scotland Act 2016, agrees. The Scottish Government produces a letter of rights which is provided by Police Scotland to inform arrested persons of these and other rights, and an easy-read version is also produced. I hope that reassures Jeremy Balfour and he will not move these amendments. I do welcome Jeremy Balfour's Amendment 201, which seeks to bolster existing automatic legal aid provision for children involved in the hearing system and ensure that there is no gap in provision in cases where the child has been reported on offence grounds following a decision not to prosecute by the Procurator Fiscal. Amendment 201 guarantees the availability of automatic legal aid in cases where a child is referred to the Children's Reporter in respect of an offence that would likely have been prosecuted on indictment had the Procurator Fiscal decided to pursue a conviction. The Scottish Government is committed to strengthening children's access to justice, and this measure will ensure that no child in these very serious circumstances is left without effective access to a solicitor. And I am happy to support Amendment 201.
Thank you, Minister. I call on Jeremy Balfour to wind up and to press or withdraw Amendment 74. Mr. Balfour.
Thank you, Deputy President Officer. I accept the reassurances given in regard to 189, 192 and won't be pressing them. And I'm again thankful to the Minister for her help in regard to 201. If I can just go back to Amendment 74 and 77, I am slightly concerned still, if I'm honest, Minister, with the reply that you've given, because I don't actually see anything changing. Simply a letter to the Law Society and to the Legal Aid Board will bring no fundamental change. And as it stands at the moment, any solicitor can appear at a children's hearing without having any training at all. And I just think that is the wrong way forward for children's hearings. We recognise that we are dealing with some of the most vulnerable children in our society, and for somebody who has never had any of this training to simply appear, I think does a disservice to the hearing and does a disservice, absolutely.
Minister.
I did highlight in my comments that the Scottish Legal Aid Board already requires solicitors working in the area of children's legal assistance to meet 5 defined standards which demonstrate their knowledge and experience in child law. I have said that I will go. I appreciate Mr Balfour is not assured by my comments and my commitment to writing to the Lord President and various others, but I think that is a good next step in understanding where there are any gaps.
Jeremy Balfour.
Yeah, I won't hold the chamber back. I don't agree with her comments. I think trauma training is vital. I don't see that as part of what we've got. So, with your permission, Deputy President Officer, I will move Amendment 74 in my name.
Thank you. The question is that Amendment 74 be agreed to. Are we all agreed? The Prime Minister is not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Point of order, Mark Roscoe.
I would have voted no.
Thank you, Mr Roscoe. Your vote will be recorded. Thank you. The result of the vote on amendment number 74 in the name of Jeremy Balfour is yes, 42, no 71. There were no abstentions. The amendment is therefore not agreed. I call amendment 75 in the name of Ross McCall. Already debated with amendment 74. Ross McCall to move or not move?
Based on what's been said, I won't move, but slightly disappointed. Thank you.
Not moved. I now call amendment 181 in the name of Bill Kidd. Already debated with amendment 171. Bill Kidd to move or not move?
Genuinely moved.
Moved. The question is that amendment 181 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call amendment 182 in the name of Ross McCall. Ready debated with amendment 171. Ross McCall to move or not move?
Moved.
Moved. The question is that amendment 182 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call amendment 183 in the name of Ross McCall. Ready debate with amendment 172. Ross McCall to move or not move?
Based on the assurances given by the Minister, not moved.
Thank you. Not moved. I call amendment 184 in the name of Ross McCall. Ready debate with amendment 172. Ross McCall to move or not move?
Not moved.
Not moved. I call amendment 76 in the name of the Minister. Already debated with amendment 48. Minister to move or not move?
Not moved.
Not moved. I call amendment 185 in the name of Martin Whitfield. Already debated with amendment 169. Martin Whitfield to move or not move?
Moved.
Not moved. I call amendment 186 in the name of Nicola Sturgeon. Already debated with amendment 169. Nicola Sturgeon to move or not move?
Not moved.
Not moved. I call amendment 77 in the name of Jeremy Balfour. Already debated with amendment 74. Jeremy Balfour to move or not move? Moved. The question is that amendment 77 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Kenneth Gibson.
Didn't access the system, and I voted no.
Thank you, Mr Gibson. Your vote will be recorded. Thank you. The result of the vote on amendment number 77 in the name of Jeremy Balfour is yes, 45, no, 69. There were no abstentions. The amendment is therefore not agreed. I call amendment 187 in the name of Martin Whitfield. Already debated with amendment 169. Martin Whitfield to move or not move? Not moved. I call amendment 188 in the name of Nicola Sturgeon. Already debated with amendment 169. Nicola Sturgeon to move or not move?
Not moved.
Not moved. I call amendment 189 in the name of Jeremy Balfour. Already debated with amendment 74. Jeremy Balfour to move or not move?
Not moved.
Not moved. I call amendment 190 in the name of Martin Whitfield. Already debated with amendment 169. Martin Whitfield to move or not move?
Not moved.
Not moved. I call amendment 191 in the name of Nicola Sturgeon. Already debated with amendment 169. Nicola Sturgeon to move or not move?
Not moved.
Not moved. I call amendment 192 in the name of Jeremy Balfour. Already debated with amendment 74. Jeremy Balfour to move or not move?
Not moved.
Not moved. I call amendment 193 in the name of Martin Whitfield. Already debated with amendment 169. Martin Whitfield to move or not move?
Not moved.
Not moved. I call amendment 194 in the name of Nicola Sturgeon. Already debated with amendment 169. Nicola Sturgeon to move or not move?
Not moved.
Not moved. I call amendment 195 in the name of Jeremy Balfour. Already debated with amendment 74. Jeremy Balfour to move or not move?
Not moved.
Not moved. I call amendment 196 in the name of Martin Whitfield. Already debated with amendment 169. Martin Whitfield to move or not move?
Not moved.
Not moved. I call amendment 197 in the name of Martin Whitfield. Already debated with amendment 169. Martin Whitfield to move or not move?
Move.
Moved. The question is that amendment 197 be agreed to. Are we all agreed?
Yes.
The Parliament is agreed. I call amendment 78 in the name of Ross McCall. Already debated with amendment 169. Ros McCall to move or not move?
Not moved.
Not moved. I call Amendment 198 in the name of Nicola Sturgeon, already debated with Amendment 169. Nicola Sturgeon to move or not move?
Not moved.
Not moved. I call Amendment 199 in the name of Martin Whitfield, already debated with Amendment 169. Martin Whitfield to move or not move?
Not moved.
Not moved. I call Amendment 200 in the name of Ross Greer, already debated with Amendment 169. Ross Greer to move or not move?
Move.
Moved. The question is that Amendment 200 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 200 in the name of Ross Greer is yes 97, no 16. There were no abstentions. The amendment is therefore agreed. I call amendments 79, 80, 81 and 82, all in the name of Miles Briggs and all previously debated with amendment 10. I invite Miles Briggs to move amendments 79 to 82 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put on amendments 79 to 82? No. If no member so the question is rather that amendments 79 to 82 are agreed to. Are we all agreed? Yes. The Parliament is agreed, and I call amendment 201 in the name of Jeremy Balfour, ready debated with amendment 74. Jeremy Balfour to move or not move?
Move.
Moved. The question is that amendment 201 be agreed to. Are we all agreed?
Yes.
The Parliament is agreed. We now turn to Group 21, places of safety for arrested children. I call amendment 202 in the name of Willie Rennie, grouped with amendment 211. And I call on Willie Rennie to move amendment 202 and to speak to other amendments in the group. Mr Rennie.
So eagle-eyed members will have noticed that we are over 3 hours ahead of the timetable agreed by the Parliament. I think there must be a... Just wait for it. There's probably a special place in heaven for the education team. But I have to tell you, the remainder of the amendments are all mine, and I can talk forever. So
Mr Rennie, I assure you, you cannot.
So moving on to my Group 21. So there is a growing consensus that police stations are generally not an appropriate environment for children, and that the number of children held there must be reduced. I share that view, and that is the reason I am bringing forward amendments 202 and 211. In my discussions with the Minister, we both recognise the need to ensure that, in future, the default position should not be that an arrested child is taken to a police station. We recognise too, however, that any reforms in this area must be safe, sustainable and allow Police Scotland to carry out their duties effectively. As was highlighted during Stage 2 proceedings, it is essential that we identify suitable alternatives to police stations before any legislative changes are made. We must also resolve outstanding matters, such as how assessments will be made about where a child should be taken on arrest and who will make those, and how the rights and protections currently afforded to children in police stations can be fully upheld elsewhere. Amendments 202 and 211 therefore allow ministers to make regulations subject to the affirmative procedure to modify the Criminal Justice Scotland Act 2016, so that a child who is arrested can be taken to a place other than a police station, and that the Act can operate to allow children who voluntarily attend at an alternative place can remain there if arrested. It is, of course, important to ensure that children's rights can be fully upheld in an alternative setting to a police station, and that the power allows for the protections in Part 1 of the 2016 Act to apply in the alternative setting in the same way as they apply in police stations. These include, for example, the right to be given certain information on arrest and the right to have a consultation with a solicitor. I recognise that in future there will be exceptional circumstances in which it will be appropriate for an arrested child to be taken to a police station. However, there will also be circumstances where an alternative would be more suitable. Under current legislation, there is no flexibility to allow that. This amendment would allow ministers to make regulations which provide that flexibility. Ministers would only be able to exercise the power to allow arrested children to be taken to places that they consider more suitable for children than police stations. Those places would only be specified either by reference to an enactment or a document. Where a document is to be used, this must be made publicly available. And if it is created or updated after regulations have been laid, consultation with the Police Service of Scotland, local authorities and any other persons that the Scottish Ministers consider appropriate will be required before finalising its content. The power for ministers to make different provision for different areas will also allow for a gradual test of change approach in different parts of Scotland to be piloted. This, coupled with the ability for ministers to impose recording and reporting obligations in the regulations, would allow for consideration of how test approaches are operating before wider implementation of reform across Scotland. I therefore move amendments 202 and 211 and invite members to support them.
Thank you, Mr Rennie. I call the Minister.
I thank Mr Rennie for bringing forward these amendments and for his interest and constructive engagement on this important issue for some of our most vulnerable children. I fully support these amendments, which will mean ministers can bring forward changes to reduce the number of children taken to a police station on arrest and pilot approaches as necessary before wider implementation. I would urge members to support amendments 202 and 211.
Thank you, Minister. I call on Willie Rennie to wind up and to press or withdraw Amendment 202.
Nothing more to add, and I'll press.
Thank you, Mr Rennie. Obviously, my gentle advice has worked. The question is that Amendment 202 be agreed to. Are we all agreed? But the Parliament is not agreed. There will be a division, and members should cast their vote now. The vote is now closed. Point of order, Elena Whittam.
Thank you, my app wouldn't connect. I would have voted yes.
Thank you, Ms Whittam. Your vote will be recorded. Point of order, Marie McNair.
My app wouldn't connect. I would have voted yes.
Thank you, Ms McNair. Your vote will be recorded. Thank you. The result of the vote on amendment number 202 in the name of Willie Rennie is yes 74, no 22. There were 14 abstentions. The amendment is therefore agreed. I call amendment 83 in the name of Miles Briggs, already debated with amendment 10. Miles Briggs, to move or not move?
Moved.
Moved. The question is that amendment 83 be agreed to. Are we all agreed? The Parliament is agreed. I call amendment 203 in the name of Willie Rennie, already debated with amendment 10. Willie Rennie, to move or not move?
Move.
Moved. The question is that amendment 203 be agreed to. Are we all agreed? The Parliament is agreed. We now turn to Group 22 on Children's Services Planning. I call amendment 204 in the name of Willie Rennie in a group of its own. I call Willie Rennie to move and speak to amendment 204.
Amendment 204 follows on from Amendment 109 in Group 5 and was also developed at the suggestion of Who Cares Scotland. Amendment 204 adds to Section 22A on the outcomes of the Children's Services Plan, which was inserted by an amendment from Nicola Sturgeon at Stage 2. It simply adds a requirement for children's services plans to include how services will be planned and delivered to support delivery of the promise. As with Amendment 109, this is intended to introduce greater accountability for keeping the promise and to ensure policy coherence across children's services, planning and the promise. Members will also note that the briefing from Children First, which supports this amendment, says children's services planning is an important tool for planning accountability and transparency, and this would be a helpful aid to support this work.
Thank you, Mr Rennie. I call the Minister.
I thank Willie Rennie for bringing Amendment 204 forward. Improved children's service planning is central to keeping the promise, and therefore, again, I'm very happy to support this amendment. Amendments at Stage 2 already significantly strengthen the children's service planning legal framework. What Mr Rennie is proposing goes further by ensuring that lead children's service planning bodies must explicitly set out within their plans how services will contribute to delivering the promise. This will improve accountability, policy coherence and strengthen the collective responsibility of local planning partners to deliver better outcomes for children and families. And I encourage members to support Amendment 204.
Thank you, Minister. And I call on Willie Rennie to wind up and to press or withdraw Amendment 204.
Nothing more to add, and I'll press.
Thank you. The question is that Amendment 204 be agreed to. Are we all agreed? The Parliament is agreed. I call Amendment 84 in the name of Miles Briggs, already debated with Amendment 10. Miles Briggs, to move or not move?
Moved.
Moved. The question is that Amendment 84 be agreed to. Are we all agreed? The Parliament is agreed. We now turn to Group 23 on reviews and reporting in relation to the Act and the promise. I call Amendment 205 in the name of Willie Rennie, grouped with Amendments 206, 207 and 208. And I call on Willie Rennie to move Amendment 205 and to speak to other members of the group. Mr Rennie.
Presiding Officer, Deputy Presiding Officer, at Stage 2, the committee agreed two somewhat overlapping review duties. This reflected a strong desire for robust scrutiny of how this legislation is implemented and to be kept abreast of developments in keeping the promise by the deadline of 2030. My amendments tidy up those review duties and avoids duplicating the extensive reporting already provided through existing promise monitoring and oversight. Amendment 205 introduces a statutory requirement for ministers to review and report on implementation of the Act within 2 years of royal assent. That ensures Parliament will be updated on implementation of the bill we are considering today. Amendment 206 then requires ministers to publish within 6 months of 2030, which is the deadline for keeping the promise, a report on how all of its recommendations have been fulfilled. Amendments 207 and 208 simply remove sections 22D and 22E, which were the review duties inserted at Stage 2, which Amendments 205 and 206 supersede.
Thank you, Mr Rennie. And I call the Minister.
Presiding Officer, I am once again very grateful to Willie Rennie for his constructive approach to Amendments 205 to 208. They reflect a proportionate and workable approach to meet the Parliament's desire for clear review points and assurance on progress towards keeping the promise, and I encourage members to support all amendments in this group. As I mentioned when speaking to Group 17, I consider it's imperative that this review also looks at the effectiveness of opt-in and demand-led advocacy in the children's hearing system and recommends any changes that need to be made. As I say, encourage members to support the amendments.
Thank you. Minister, I call on Willie Rennie to wind up and to press and withdraw Amendment 205.
Nothing more to add, and I'll press.
Thank you. The question is that Amendment 205 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call Amendment 206 in the name of Willie Rennie, already debated with Amendment 205. Willie Rennie to move or not move?
Moved.
Moved. The question is that Amendment 206 be agreed to. Are we all agreed? The Parliament is agreed. I call Amendment 207 in the name of Willie Rennie, already debated with Amendment 205. Willie Rennie to move or not move?
Moved.
Moved. The question is that Amendment 207 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call Amendment 208 in the name of Willie Rennie, already debated with Amendment 205. Willie Rennie to move or not move?
Moved.
Moved. The question is that Amendment 208 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call Amendments 209, 86 and 87, all in the name of the Minister and all previously debated. I invite the Minister to move Amendments 209, 86 and 87 en bloc.
Moved.
Thank you. Does any member object to a single question being put on Amendments 209, 86 and 87? No. The question, therefore, is that Amendments 209, 86 and 87 are agreed to. Are we all agreed? The Parliament is agreed. I call Amendment 210 in the name of Martin Whitfield, already debated with Amendment 145. Martin Whitfield to move or not move?
Not moved.
Not moved. I call Amendment 211 in the name of Willie Rennie, already debated with Amendment 202. Willie Rennie to move or not move?
Moved.
Moved. The question is that Amendment 211 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call Amendments 88, 89 and 90, all in the name of the Minister and all previously debated. I invite the Minister to move Amendments 89 to 90 en bloc.
Moved.
Thank you. Does any member object to a single question? A member does object. Therefore, I will put the question on each amendment individually. The question is that Amendment 88 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 88 in the name of the Minister is yes 99, no 17. There were no abstentions. The amendment is therefore not agreed. The question is that amendment... Oh, I beg your pardon. Indeed. I'll repeat. So the vote on amendment number 88 was therefore agreed. Sorry, I'll get there at the end of the day. It's been quite a long couple of weeks. So the question is that amendment 89 be agreed to. Are we all agreed? The Parliament is agreed. Amendment 89 is therefore agreed to. The question is that amendment number 90 is agreed to. Are we all agreed? The Parliament is agreed. That ends consideration of amendments. There will be a very short pause.
Sorry about that last one.